Hi, this is Margie Connolly, estate planning and probate attorney with the law firm of Margaret Connolly, PLLC. And I'd like to take a minute to talk to you today about 4 legal questions that everyone should have answered for peace of mind. Because let's face it, during this past 2 years of COVID-19 pandemic, we have all become confused and frustrated. Many questions have come into our mind, but a couple of things are crystal clear. 1, serious, life-changing, and potentially fatal health issues can occur at any time and without warning. We need to have a plan in place before they happen, and that is the thing I'm here to talk to you about today. No one likes to think about what would happen if you or your loved one are incapacitated or become deceased. But the consequences of inaction today can turn a tragic situation into a legal nightmare. This is the cross-section where mortality meets legality. So let's talk about 4 things that if you can answer them, that will give you peace of mind in case something should happen to you. 1, if I'm incapacitated, who will make medical decisions for me? If you are unconscious and unable to consent to medical treatment, the doctors or hospital personnel may or may not seek your spouse's consultation on these things. Without legal authority, they are not allowed to give your medical information to anyone but you. If you have the proper paperwork, medical directives, medical power of attorney, and HIPAA releases in place, this problem can be solved and things can go smoothly. Second question, who will be responsible for paying my bills and debts and taking care of my property if I become incapacitated or pass away? Again, proper legal authority given to your spouse, who doesn't always have it just because you have a marriage license, or to an adult child, a sibling, or your parent. But someone has to have legal authority to take care of your legal affairs, your financial affairs, if you're unable to do so for any period of time. What happens, number 3, to my dependent children if something should happen to me and my spouse or the other parent of the child? Very important question, because without legal authority to care for your children, other relatives who are not parents of the child do not have the right to do that, and the children could be taken away and placed in the care of child protective services. So please consider guardianship and power of attorney paperwork to make sure your children are taken care of. And number 4, conversely, if you have elderly parents who are relying on you to help care for them, either financially and physically or both, please make sure you have proper paperwork in place, guardianship papers or powers of attorney, to make sure that someone can step into your shoes and take care of your parents if you are unable to do so for a period of time due to incapacity, illness, or death. So please make a plan to talk to an estate planner, an attorney, or a financial planner, or a legal consultant about what to do to make sure that your loved ones and your assets are taken care of in the event something happens to you. Because if you fail to plan today, it's just like planning to fail tomorrow. We don't know what the future will bring, but we can control the legacy we will leave with proper planning. Thank you.